thank you for being on time. We have continuing proceedings post-judgment on the Ghibaudo matter, D 2015-522043. In court present, we have Mr. Ghibaudo, and we have Ms. Kramer, counsel for Mr. Ghibaudo on the Ghibaudo Professional Corporation. Ms. Kramer, do you want to state your appearance?
Yes, good afternoon, Your Honor. Shancy Kramer, bar number 11545 for the defendant who's present and for the defendant corporation.
Okay. Like last week, we have Mr. Nelson representing Ms. Kellogg. Both of them have elected to participate through a Blue Jeans connection, and we should have Mr. Nelson connected and Ms. Kellogg connected. Mr. Nelson, will you state your appearance?
Thank you. Good afternoon, Your Honor. Attorney Jonathan Nelson, Nevada Bar 12836, on behalf of Ms. Kellogg, who is present, as you mentioned, via Blue Jeans appearance as well.
All right, my clerk, can you just confirm that the only folks connected remotely are Ms. Kellogg and Mr. Nelson?
Yes, Your Honor, only Ms. Kellogg and Mr. Nelson.
All right, we understand that Mr. Marin, who was unavailable on the 19th of August, and Mr. Reed also may be available by Blue Jeans connection to be fact witnesses in this case?
Yes, Your Honor.
All right.
Just to kind of proceed.
When they're needed, we will break them in one at a time. This matter we were unable to conclude it in the 3 hours that we heard it on August 19th. We took testimony from Don Ferrer, who was employee of the resident agent. We took testimony from Mr. Ghibaudo, and we had some short testimony from a deputy constable who attempted to serve in December. So I want you to, as efficiently as you can, conclude your case. And I know that you were efforting when we recessed the case last time to try to get, I don't know what the first name is, but Marin, the one who signed the writ of garnishment affidavit. My clerk says that there's somebody by that name who's logged in. Is that your first witness?
That's what I'd call first.
All right.
Yes, Your Honor.
What is the first name of the witness?
Bear with me. I believe it's Thomas.
All right. Well,
Thomas Marin.
All right. Will you break him in, please?
Yes, Your Honor. He's in, Your Honor.
All right, Mr. Marin, my name is Art Ritchie. I'm the judge that's managing this case. Are you Mr. Marin from the constable's office? Please unmute yourself so we can hear you.
Mr. Marin, you're on mute. Can you unmute yourself?
Yes, I'm sorry about that.
All right, that's fine. Mr. Marin, I'm glad you're available today. This hearing actually began on the 19th. I understand that you were subpoenaed to testify in the case, and we're going to call you at this time. Ordinarily, you would be in court here. Is there any way that you can activate the video and audio portion of your connection?
Yes.
All right, good. We're gonna have you take an oath, just like if you were in court. You don't have to stand. Just raise your right hand, please.
You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, excellent. So, Mr. Marin, I want you to state your name and spell it for the record, please.
Thomas Marin, Thomas Marin, Marin.
All right, excellent. Mr. Nelson is going to ask you questions first, and then the other party, Ms. Kramer, represents the defendant, and she'll ask you questions to try to get you in and out of here as quickly as we can, okay?
Thank you.
All right, Mr. Nelson.
Thank you, Your Honor. Mr. Maron, can you tell me what your line of work is?
I work for the constable office as a deputy constable.
And how long have you worked for is that the Las Vegas Constable?
Yes, sir.
And how long have you worked there?
About 6 years now.
Okay. And as part of your duties, do you serve various legal pleadings?
Yes.
And do those legal pleadings that you serve include writ of garnishment?
Yes.
Okay. Now this is tricky because we're not here in person, and I don't know if you can get access. Your Honor, I emailed Mr. Merritt a proposed exhibit for his review. I don't know if you can pull that up, Mr. Merritt. The email.
I have a log that recalls my memory on the date and the person I served that garnishment, that writ on.
So do you recall serving a writ of garnishment on or around January 12th of this year to Don Ferreira?
Okay, I don't have that one, but the one that you sent me, I have it listed on my log for January
I
29th.
object to this testimony. He's referencing documents that we don't have.
Look, Mr. Nelson, you've got to be more specific. I mean,
Okay,
attached to the motion.
that's fine. I mean,
Are you showing him the Office of the Constable writ of garnishment affidavit or some different document?
No, I'm showing that, as I mentioned, proposed exhibit 15, so I believe counsel should.
Does the witness have proposed exhibit 15?
I just emailed that to him. I'm not sure if he's able to pull it up, but I believe if I may lay out a little more foundation, Your Honor, I think we can talk more thoroughly. Mr. Marin.
The objection is sustained to the extent that the witness, I mean, it was unintelligible as to what he was even talking about or what he was looking at. You can put the document up for him to see on the screen if you want. But this document has been in place since the motion was filed in April. This was a document that was offered. It is, I assume that what you're going to be asking the witness is whether this is the document that he signed, right? All right. So, Mr. Marin, do you have a document, a one-page document, which is called an Office of Constable writ of garnishment affidavit? Do you have that in front of you?
No, I don't have it, but I see it on your screen.
All right.
I'm sharing it as you per Your Honor's recommendation.
Mr. Nelson, ask your question, please.
So this document that's on the screen, do you recognize this document?
Yes, I recognize the document.
Is this a standard form that you and your office typically use?
Yes, it is.
So can you review the document and tell me what it states?
It shows January the 12th, the 21st, when I received it, and it shows January the 12th when I served the document to Devon Fiera at 10161 Park Run Drive, Suite 120, zip 89145. At the bottom, it shows my signature, my personnel number, and it also shows the date that I completed the affidavit.
And it also states in that you tendered the statutory $5 to Ms. Ferrara. Is that correct?
Yes.
And then that's your your declaration under penalty of perjury. That's your signature below that statement.
Yes, it shows my signature and my name stamp with my P number.
Do you have any relationship? Have any knowledge of either party in this matter?
No, I don't.
Okay. So do you have any reason to not set forth your record as accurately as possible?
Yeah, no, I have no reason to dispute it.
Okay. Would this have been signed by you if you had not served the writ of garnishment and tendered the $5?
No, it would not have been signed.
Okay. I have no further questions for this witness, Your Honor.
Okay, Ms. Kramer, do you have your questions?
Yes, Your Honor. Mr. Marin, do you recall what the person you served looks like?
Served so many of them, I can't recall right off the bat unless I saw that person.
Okay. Mr. Marin, it indicates here on Exhibit 15 that you served a check, but do you recall having that check in your hand?
No, the check is attached to the writ of garnishment. So, day before, I looked through both the packages to have both of those documents to make sure that they're there.
Okay, and
So if it wasn't, I'll give it back to you.
Mr. Marin, who prepares this form that you, this form that is Exhibit 15 that's on the screen?
I fill out that affidavit.
No, that's not what I asked you. Well, my question was, who prepared the form?
I don't know.
Well, it's clearly a
Confusing.
form that you filled in the blanks on, right?
Yes, it is.
Okay, so where did you get that form to fill in the blanks?
Provided by the constable's office.
Okay. Do you recall what color the check was?
No, I
Objection.
don't.
He's already answered. He doesn't recall.
No, overruled. He can answer the question.
Fair enough.
No, I don't recall what the color of the check.
Okay. Do you recall how the check was fastened to the writ?
It was stapled to the writ.
Okay, and do you recall who wrote that check?
No, I don't.
Do you recall which bank that check was drawn from?
No, I don't.
Okay. The court's indulgence, please, Your Honor. All right, Your Honor, I'll pass the witness.
Any redirect, Mr. Nelson?
No redirect, Your Honor.
Okay, this witness was subpoenaed by you for this short hearing, right?
Yeah, yes, Your Honor.
Any objection to releasing him from this subpoena at this time?
No objection here.
No.
Okay, Mr. Marin, I want to thank you for being available on time so that we could get your testimony completed, your release from the subpoena, okay?
Okay, thank you.
Now, what, Mr. Nelson, you mentioned briefly that you were thinking about calling Mr. Reed as a fact witness. What is, I'm a little concerned about that. I know he's formal counsel, and I kind of have an idea what that might be about based on the last session. What are you going to be asking about? Any kind of requests or whether he sent anything to Mr. Ghibaudo?
That was the one line of question, but also, there's been concerns about the tendering of the $5, and I believe Mr. Reed, the check was drafted for Mr. Reed's operations or truth.
That is testimony by counsel.
It said, look, nothing you say or nothing that Mr. Nelson says is evidence. It's not for proof. It's in response to the court's question as to whether it's relevant information that needs to be called or whether it's a needless presentation of cumulative proof. You have told the court that the court should deny the motion primarily because there was no proof that the garnishee was paid the $5 and that the resident witness didn't have authority to accept and that Mr. Ghibaudo didn't have any notice. And so these are factual disputes that the court is going to have to resolve. And so, as long as we're not calling him to testify about anything that would be privileged, just facts that would be related to the contested pieces in this case, I don't necessarily mind. But I don't remember him being identified as someone who might be testifying in this case. Is that to rebut the testimony of Mr. Ghibaudo?
That is, Your Honor. Because Mr. Ghibaudo did not recall and wasn't sure that he was sent things from Mr. Reed. Didn't recall the correspondence. So it was to rebut Mr. Ghibaudo's testimony.
Do you really think it's material at all to the elements that the court has to find that there was a discussion in a settlement conference in March and a request to send the papers to him? I mean, what is that? What relevance does that have to whether or not the garnishee suffers a judgment because of service that happened in January?
Well, Your Honor, there's two issues. Ms. Kramer has been banging the drum to lack of service and lack of the tendering. And again, the statutory clear, it's tendering, not payment. But nevertheless, she's been beating that drum that didn't happen. I would argue that, yes, it did. I think we've proven that those elements there, but notwithstanding.
Well, what we have so far is we have the resident age's testimony that they were paid. We have the constable's testimony that they were paid. We got Mr. Ghibaudo's testimony that he didn't get the $5, and so that's where we're left. If that's, I don't know that Mr. Reed wrote the check, but you'll have to lay a foundation about whether or not he knows one way or another. Okay, I just don't want his testimony to be a labored or long exercise because I'm not so sure that we need the testimony to establish that there was a dialogue around the end of March or early April about the writ, and whether there was communication between Mr. Reed and Mr. Ghibaudo concerning the writ. That was established by an email and by the testimony of Mr. Ghibaudo. But if you're concerned that the lack of knowledge or lack of recollection by Mr. Ghibaudo needs to be addressed with the testimony of Mr. Reed, as long as Mr. Reed has actual, he's the real witness, he's got personal knowledge. I don't want him testifying about stuff his staff may have done or whatever, okay? All right, why don't you break out Mr. Reed, please? Okay, Mr. Reed, you've joined the proceeding. We're in court on the record. The defendant and defendant's counsel are present in court. Mr. Nelson is present, and Ms. Kellogg is present through a Blue Jeans connection. You've been identified as a fact witness on a couple of points related to this dispute. And were you subpoenaed to testify, Mr. Reed?
I was not.
Okay, and I see you in the box. Madam Clerk, will you swear him in, please?
Mr. Reed, you do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Mr. Reed, just making the record, could you state your name, spell your last name for the record, please?
Robert Christopher Reed, R-E-A-D-E.
And how do you know Kellogg?
I know Ms. Kellogg because I was her prior counsel.
Okay. Just as prior counsel, did you assist in preparing a writ of guard against Alex Ghibaudo, PC?
I'm sorry, could you repeat the question?
When you were prior counsel, did you prepare or attempt to serve a writ of garnishment against Alex Ghibaudo, PC?
I prepared an original writ of garnishment, writ of execution, notice of execution, and instructions to constable. And then I prepared an amended writ after that.
And did you engage the Las Vegas constables to serve those on the registered agent of Alex B. Ghibaudo, PC?
For clarity, the first writ was we engaged the constable to deliver to Alex B. Ghibaudo, PC, at its office. When that did not occur, we had the amended writ served through the Las Vegas constable upon the registered agent, which is, I believe, Mr. Hutner's office.
And do you recall when that second attempt was actually served? Do you recall the month and year?
I think the amended writ was issued around January 5th or January 6th of 2021. I believe it was served by the constable, according to the affidavit, on January 12th of 2021.
And I don't know if you're able, hopefully you're able to screen, I believe it's proposed exhibit number 4. It's a check, it looks like to be written off of your firm's account payable to Alex B. Ghibaudo PC. Do you recognize that check, Mr. Reed?
I do.
And is that a check written from your firm's account?
That's written from our general account.
Okay. And whose signature is that on the bottom?
That's Deborah Reed's signature.
And what's Deborah's relationship to you?
She's my wife, my office manager, and, well, as I think this case shows, sometimes owns some of my stuff.
So do you have direct knowledge that this was written and provided to the constable's office?
I do.
Okay, what knowledge would that be, just for record's sake?
Well, I'm a signatory on the account, as is Deb. Plus, this check, along with the writs, were delivered by me to the Las Vegas constable's office.
Okay. And to your knowledge, this was served along with the amended writ to Opner and Associates?
To the best of my knowledge, this check, along with the amended writ for garnishment and execution, were served by the Las Vegas constable.
All right, and then finally, Mr. Reed, do you recall an email conversation with Mr. Ghibaudo 8 March of this year concerning the writ of garnishment?
I do.
Did Mr. Ghibaudo advise you that he was aware of the garnishment?
I got an email after a Nevada Supreme Court settlement conference that he had been told by the settlement judge that there was a writ that had not been answered, and I received an email from Mr. Ghibaudo in which he asked if we could send him the writ.
Okay. And did you comply with that?
I complied with that by forwarding it to my legal assistant, Elizabeth Arthur. She sent the writ with the attachment.
This is hearsay.
He can say what he, all right, look, be careful, ask the question specifically. The real witness might be his legal assistant as to what was done or whatever. Mr. Reed may have corrected this particular act. So restate the question or direct us to answer concerning his actions.
So Mr. Ghibaudo asked you to forward the writ and the accompanying information to him, correct?
I believe that was the sum and substance of the email, yes.
And in response, you directed your legal assistant to forward those items to him.
That is correct.
Were you carbon copied on that email to Mr. Ghibaudo?
I can't remember if I was originally carbon copied or if it was forwarded to me right afterwards, but I received a copy because I needed confirmation it had actually gone.
Okay. So to the best of your knowledge, those documents were provided to Mr. Ghibaudo following his request?
Correct.
I have no further questions for this witness.
Ms. Kramer?
Yes, Your Honor. So, Mr. Reed, you admit that you were notified by Ishii Kunin during the settlement conference that Alex had not received the writ, correct?
I don't remember Ishii telling me that. She may have. I don't recall that.
Okay, so then you do admit that Alex notified you by email that he hadn't been served, correct?
I did get an email from Mr. Ghibaudo after that settlement conference in which he stated that he did not believe he had been served with the writ, yes.
Okay, so you were aware that there was an issue with service, even though you claim that he was served in April, or excuse me, strike that. You claim he was served in January, on January 12th, through the registered agent, but you found out in March that he did not know that you had been attempting to serve him, correct?
Objection calls for conclusion and facts not evidence.
Yeah, look.
This is all stuff he just admitted.
No. Their position is that the service in January was valid, whether Mr. Ghibaudo found out about it or not, because it was delivered to the resident agent, okay? your defense is that because he didn't have actual notice, even though it was delivered to the resident agent, it wasn't serviced.
No,
That's
no.
the legal
Our-
issue the court decides.
Our position is that the
Well,
registered agent
you
was
have a
not.
bunch of different positions. That's one of your positions that you mentioned last week. It's neither here nor there. You're gonna argue it in a little bit.
Okay,
The question asks for a legal conclusion, and it is not, and the objection is sustained. You can ask him, another question if you want to make the point about whether he knows or doesn't know whether Mr. Ghibaudo had actual notice.
All right.
Whatever point you want to make.
Mr. Reed, have your bank statements indicated that that check that you have at Exhibit 5, that was cashed?
Objection relevance, Your Honor. Tendering is not the same as cashing or keeping.
Then the objection as to relevance is overruled. I don't know whether it's material or relevant, but the question is fine. I'll let him answer it. I mean, look, if I don't know that it matters, but the court is going to allow, if he knows, the witness to answer the question. Was the check negotiated, is what you're asking him, right?
Correct, Your Honor.
All right.
As the last time that I looked, which was when I was still on the case, the check had not been negotiated.
Okay, so when you emailed Mr. Ghibaudo the writ and the interrogatories in March, did you send another check?
No,
Did you transfer $5 to Mr. Ghibaudo?
no,
Did you in any way tender $5 to him when you emailed him the writ and the ROGs in March?
no.
This check that is attached is your exhibits. It is dated December 21, 2020, correct?
Correct.
Okay, so you indicated that you initially tried to serve our office but was unable to, correct?
Correct.
So did you use the same check in the amended writ?
Yes. The constable, when they couldn't effectuate the first writ, returned it with the affidavit to us of non-service, along with the check.
Okay, and so then you sent that check again to the registered agent in January. Is that what you're saying?
Yeah, we took our writ packet with the $5 check, a check for the constable, because the constable required a new check for a new service, down to the constable.
Okay, so you didn't try to send another check in March, though, did you?
No.
Okay. Your Honor, pass the witness.
Okay, Mr. Nelson, anything else?
Just real quick, this was brought up. Mr. Reed, you spoke earlier in questioning about email correspondence between you and Mr. Ghibaudo concerning the writ. You have before you Exhibit 18, date stamps, Kellogg 078. Be able to kind of review that? Is that, my understanding is that is an email to you from Alex, is that correct, to your knowledge?
Yes, that is correct.
And can you read what that last sentence of his, well, read the whole thing. Can you read that so we can make sure I understand?
You want me to read it to myself or read it aloud?
No, read it out loud.
Chris, we never received the writ of garnishment. We became aware of it because Ishi mentioned it. If you can send it to me by email, I will respond.
Okay. I want to direct your attention to Exhibit 17, Kellogg's bait stamp 077 for everybody. What is this document, Mr. Reed?
This is an email from Elizabeth Arthur, my legal assistant, to Mr. Ghibaudo, CC'd to me. It looks like on March 17th, 2021.
So, kind of following back to your testimony earlier, once Mr. Ghibaudo requested the garnishment in the writ, you promptly provided, had your office provide that to him, is that correct?
Yes, that's correct.
And is it fair to say, based upon his email of provide it to me and I'll respond, you were led to believe that if you provided that, he would respond accordingly?
Yes.
Did Mr. Ghibaudo ever raise the issue of the $5 at that point in time?
No.
And frankly, at any time after he provided this, did he provide any sort of response to the writ of garnishment?
When the opposition to the motion was filed.
Okay. But not until that time. And when was that filed? Your knowledge, if you would.
I think our original motion was filed in April, because I think we waited until 30 days or so after this email was sent. And then I think that's when the respective motions were filed. And he filed an opposition, if I recall, pretty quickly thereafter.
I have no further questions, Your Honor.
Ms. Kramer?
No further questions for this witness, Your Honor.
Okay, good. Then, very efficient. Mr. Reed, I appreciate your testimony. You're excused.
Thank you, Your Honor.
Do you rest, Mr. Nelson?
Yes, Your Honor.
Okay, great. So, Ms. Kramer, are you going to put on anything, or are you just going to make an argument?
I'm just going to do a closing, Your Honor.
All right, good. Then, we have accomplished what we wanted to accomplish. When the court set the matter, it wanted to have an evidentiary record that would,
Yeah. Sorry, point of clarification. I wanted to move to enter Exhibits 4 and 15. They were testified to by both parties. I wanted to make sure I got that. Sorry.
4 and 15?
4 was the...
Well, 15 was the affidavit of service from...
Yeah.
Do you want a stated objection for the record, Ms. Kramer?
Not on 15, no, Your
All
Honor.
right, 15 is admitted. What was the other one? The 4 was the...
the check.
Right, and do you want to state an objection to that?
No, Your Honor.
Okay, so 4 is admitted. And what was, did you offer 17 or 18?
I believe those were already offered the last hearing, but in the extent they were, I'd offer those since they were foundations.
Because of Mr. Ghibaudo's testimony, I don't think 18 was admitted. Do you know if 18 was admitted?
Yeah, 18 was admitted.
All right, so 18 was admitted.
I'd also move them to 17, Your Honor.
You want to state an objection to 17?
Yes, Your Honor, I object to 17 for lack of foundation. This is hearsay. And
Well,
authentication.
I know I don't know whether we are really going to argue that Mr. Ghibaudo didn't get an email with the paperwork, but if you do, then that's fine. The foundation and why it's going to come in over your objection is that Mr. Reed testified that he directed that it be sent by email and that he was copied with the email and he received the email. And his testimony is foundation that will allow it to be entered at least for that purpose. And so the objection is overruled and 17 is admitted. Can you think of any other evidentiary pieces that we need to cover?
I don't believe so, Your Honor.
Okay, so we had our opening. We have had testimony from the 5 witnesses over the session from August 19th and August 26th. I want you to make sure that you have an opportunity to make a brief summation, and then the court will see whether it will make its findings. Ms. Kramer, that would also be an opportunity for you to restate your objections as far as, I guess, jurisdiction, due process, that kind of thing. So, Mr. Nelson, you first.
Yeah, Your Honor, I'll be very brief. I mean, this is a rarity that we're at an evidentiary hearing when the court's been presented with, prior to even the evidentiary hearing, affidavits by, unrelated third-party constables saying, yes, we served the registered agent. The registered agent at the time of service was Hopper and Associates. We brought in Ms. Ferreira this last week that testified she would have received it. They were the registered agent until just a few months ago, in fact. Mr. Ghibaudo, in comprehensible, incomprehensible, doesn't remember whether it's 19 or 20 or who's the RA. You know, the reality there is you should.
That's insulting, and there's no need for that. That's argumentative, and it misstates facts that are simply not in evidence.
I think it's closing argument, Your Honor.
Yeah, well, look,
There's no need for
he wasn't.
He doesn't need to be disparaging in his closing.
Yeah, you know what? He was like that last time, and I do take offense.
All right,
Remember?
well,
you need to be
look,
respectful.
there were some questions that were answered in which there was a response, and there were some questions that were answered in which the witness could not recall. I didn't take it as a disparaging comment, but it's a, you know, what the court is being asked to in some respects is to determine whether there's sufficient proof on some of the contested matters here. So I guess really, Mr. Nelson, you're being criticized for not really saying what you mean. You're really commenting on whether or not that testimony is credible or whether it provides any kind of sufficient defense.
That was literally coming out of my mouth, but yes.
I know. So I think you were trying to be nice and they took offense to it. Really what you're doing is you're arguing to the trier of fact as to what I do with the testimony, right?
Correct, Your Honor, and I won't be as nice. The reality is Mr. Ghibaudo came in front of Your Honor. He couldn't come up with definitive answers. They have filed repeated objections and oppositions to this, despite the facts being what they are, that we have affidavits by constables saying that his RA was served. He didn't know when his resident agent had been changed, who it was. The reality was there was no change from Hopner & Associates until earlier this year when he changed it with the Secretary of State. So when Mr. Reed caused the constables to serve Hopner & Associates, that was a valid service. Now they raised issues about, oh, well, there's ties to Hopner & Associates, to Miss Kellogg and her family. But they've offered no proof of that other than the testimony of Mr. Ghibaudo. When frankly, I've offered testimony from Don Ferreira from Hopner & Associates that says, yeah, there's no reason that we would have that or not accept service. So you have two competing witnesses and testimonies, and that's where you as the trier of facts has to weigh it. But I would say, Your Honor, should give more weight to Ms. Ferraro because of the fact that Mr. Ghibaudo, he runs his own business. He doesn't even know who his registered agent is. I take great offense to that as a business owner myself and just believe that he's not being forthright with Your Honor.
Easy, buddy.
All right, just relax.
Excuse me, Your Honor.
There was an interruption and it became garbled, okay? It was explained in the context of, if I believe the testimony that even though technically they were the resident agent, they weren't doing business together. But that's really, has nothing to do with this issue, okay?
The issue is there was service effectuated. The tendering of $5 was made. There was a check written. It was provided to the constable. It was served to the resident agent. Ms. Kramer will lead this court to believe that unless it's cash, that's not tendering, but that is not tendering. Tendering is providing the $5 by way of legal, check or tender cash, and that was done. There was testimony by Mr. Reed that it was done. There was testimony by the constable that, yeah, he would have served it stapled to the writ. There's been nothing to dispute that other than Mr. Ghibaudo saying, I didn't get it. But there again, Your Honor, even if you're inclined to say service wasn't done right in January, I would lead you to the exchange that took place between Mr. Ghibaudo and Mr. Reed in March. He waived service at that point in time by saying, get it to me and I'll answer it. And it doesn't have to be on the electronic service. If you look at NRCP Rule 5, it allows service by electronic means consented to in writing by the party. So there's a 1-2 step here, Your Honor. I think dead on rights, Mr. Reed had effectuated service by way of the constables. If you're going to listen to Ms. Kramer and Mr. Ghibaudo, give you the runaround on why it wasn't, then at least, at the very least, look to the exchange that took place in March. This is ridiculous. We're here on a second day. I think Your Honor senses that. But I think we've met our burden. I don't think Mr. Ghibaudo and his counsel have.
All right, Ms. Kramer, your summation, please.
Your Honor, contrary to what Mr. Nelson has just said, actually his witness, Mr. Marin, did not recall any of the service. The only way he recalled was by reading the plaintiff's exhibit. He did not recall anything on there. He didn't recall the date. He didn't recall any of it. until they emailed him the exhibit, and then he read what was on his exhibit. As he testified, Your Honor, that exhibit is a form that's prepared by his office. So it doesn't have a blank for him to list in his own handwriting what documents he served. It just says the writ and the check. And so he just fills in the date and signs it. And so he did not recall any of it. So Mr. Nelson has made a very clear misstatement of the facts in the testimony here. And in fact, Mr. Marin admitted he did not recall what color the check was. He didn't recall what it looked like. He didn't recall how it was attached. He didn't recall what bank it was drawn from. He didn't recall any of that. What we did here is we heard Mr. Reed testify that the first writ he tried to deliver to our office. No one in our office was aware of that. Then he testifies that he did the amended writ and served the registered agent. Now, the registered agent is extremely problematic, Your Honor, and I do believe that the court has framed this issue incorrectly. The issue is not, was this a registered agent, or was this a registered agent that was authorized to accept service, or was this a registered agent who was on the Secretary of State's paperwork? The issue is, was this registered agent authorized to accept service for this defendant and for this corporation? And the answer to that is no. And you heard Mr. Ghibaudo testify that Hopner and Associates had terminated their contractual relationship with Alex several years prior when the litigation between Alex and Tara began, because Alex needed his books done for that case, and they would not be involved because of their long friendship with Tara's family. And that's where the discovery issues come in, Your Honor. My client was prevented from conducting discovery. We do have an objection to the Discovery Commissioner's DCRR pending, and that has not been heard. My client is being denied due process in that regard, Your Honor, because we have not been able to obtain or provide the court the evidence in that regard. This is a fraudulent action that was conspired to by the plaintiff and her family and this registered agent who has been a family friend for over 2 decades. And you will recall, Your Honor, Ms. Ferreira admitted that Alex was referred to their office by Ms. Kellogg. You also heard Ms. Ferreira admit that her office prepared the filings with the Secretary of State for Mr. Ghibaudo. So when they terminated their contractual relationship, they did nothing to take it off the Secretary of State's website. They terminated that relationship. They were no longer authorized to accept service, and yet they did, and then never notified my client. And we were stonewalled from conducting that discovery. And I think it's very important here, Your Honor, to note that part of our objection is that Ms. Kellogg made allegations in her discovery motion work that you yourself found her to be dishonest or lacking in credibility at the last trial. You yourself found that she did not provide any evidence of a disability, and yet that is the exact excuse that she used before the Discovery Commissioner to prevent us from conducting our discovery. Ms. Kellogg has a real credibility issue here, Your Honor, and I know that Your Honor remembers the trial, and I know that Your Honor remembers making those findings. Now, if we look at this, we have 2 situations. We have case number 1, where the plaintiff has alleged that they served the registered agent in January. And as I've previously stated, this was deficient service because there was no authorization for Hopner and Associates to accept that service. That contractual relationship had been terminated because of their relationship with the plaintiff. And yet, they did accept the service, clearly, and never notified the defendant. Now, the next argument they have, excuse me, I'm going to go back to that first situation. That creates the issue of fraud for the court, Your Honor, because the plaintiff is engaged in fraudulent activity with her family friend against my client. And now we look at situation number 2, where if they're alleging that March was good service, then they want to say that Alex emailed and said, go ahead and send me this, and then they emailed and Alex never answered. Well, if that is all accepted as true, Your Honor, the March service is defective because there was never a check presented. And so we have defective service in both situations. We have Mr. Reed admitting that the check was never negotiated. He admits that based on his bank statements, that check is still outstanding. My client has testified that he never received that check. And so, Your Honor, regardless of whether you look at the January service or you look at the March service, which the plaintiff has alleged, apparently they're alleging both instances were good service. If you look at either of those situations, they are defective. And so that's why the plaintiff's cause of action here, Your Honor, must fail.
Anything else?
No, Your Honor, that's all I
All
have
right,
for the
that's
court.
fine. Mr. Nelson, any brief rebuttal?
I would just one thing, Your Honor. You know, Ms. Kramer wants to direct the court's attention to whether there is authorization to accept or not. You know, I believe that NRS 77370, essentially a registered agent is somebody authorized to receive service of process. The testimony by Mr. Ghibaudo, again, lacked time frames or notice. Supposedly he was told by Ms. Ferrara, although she did not testify to the same, that they weren't going to serve as the RA, but yet no paperwork was changed. So for at least a year, because again, Mr. Ghibaudo didn't know if it was 19 or 20, but at least a year went by and the registered agent remained the same entity, and that to me reflects that this entity had the authority to accept service. To rule another way would put at risk all of the service issues in any case, whether it be a writ or whether it be a complaint or any action taken, because you're then going to put the owner of a business or the appropriate parties of the business saying, oh yeah, they were listed on the Secretary of State for 2+ years or 1+ years as my resident agent, but they weren't authorized to accept service. So I think you should disregard that because again, there was not to mention there was no substantial testimony or evidence to show that, but to the extent that you give credibility to Mr. Ghibaudo's testimony, I think that's a red herring. The fact remains that the registered agent was Hopper & Associates until June of this year.
All right. There's some significant value from the court's point of view to having the hearing that we've had on August 19th and August 26th concerning a matter that probably is handled many times in a perfunctory way. And I'll explain what the reasons are for that. But the plaintiff in this case is a judgment creditor against Mr. Ghibaudo. Those judgments are judgments that were entered for child support arrears, spousal arrears, medical arrears from September 12, 2017. Now the court spent I don't want to say many days, but several days litigating issues that have nothing to do with that judgment. And the findings of fact, conclusions of law that was filed on November 10, 2020 resolved those issues. Similar claims, financial claims between the parties. There was a notice of entry of that order, and both parties exercised their rights to file notices of appeal in December. And that matter is still pending, either with the Nevada Supreme Court or the Nevada Court of Appeals. And so the court, in order to proceed on this case, has to have jurisdiction. And the court determined that it is collateral to the appeal. Certainly it's related to judgments that predate the matters that are on appeal by several years. And the court made a record of why the motion for a judgment against the garnishee could be decided, not to mention the jurisdictional provision of NRS 31.280, which says that the sheriff's return of the writ of garnishment showing due service of the writ of garnishment upon one or more garnishee defendants with the payment or tender of a garnishment fee shall give the court jurisdiction to proceed against each garnishee. And so the court didn't just say, look, this matter's on appeal, we'll deal with it, some other time. April 21, 2021, Ms. Kellogg filed a motion for a judgment against the garnishee. She already has judgments against Alex Ghibaudo. She wants judgments against Alex Ghibaudo PC, which is a Nevada professional corporation. That motion was opposed immediately. April 22nd, 2021, there was an opposition. There were defenses that were offered saying that the resident witness was not served. There was no proof of service under the statute. The resident witness had no authority to accept service, and that there was some fraud or collusion between the judgment creditor and the resident agent. Now, we had an affidavit of service. We had no answer. The court is directed under 125 or NRS 31.320 that says that the court shall, upon application thereof by the plaintiff, with at least 5 days' notice of the hearing, upon application given to each defendant who has appeared in the action, enter judgment in favor of the defendant for the use of the plaintiff against the garnishee, for the value of the amount of the money that would satisfy. And it says in section 2 that upon the motion, the court will consider claims and defenses, civil claims and defenses. And so when I read the opposition and the reply and the motion, and see that we have a judgment creditor, former spouse of the defendant, who wants to get a judgment against the defendant's corporation, professional corporation, he's the sole owner of that corporation, the court determined that there should be a hearing. And the court sits as the trier of fact and also the manager of the law. The court obviously would not proceed if it thought that having a hearing a little over 4 months after the filing, after this matter was set in June, that there's any violation of either procedural or substantive due process. The issue is, was there service on the garnishee, was there an answer, and should the judgment be entered against the garnishee? We heard testimony from 5 witnesses and received documentary proof. The court considered the arguments. In order to determine that there was no service of the writ, the court would have to basically reject and not believe the testimony of the employee of the resident agent and the deputy constable, ignore the documentary proof, and the testimony of the employee of the resident agent and the testimony of the deputy constable who did the service was credible. The trier of fact concludes and finds that the Ghibaudo PC was served legally and was served as a matter of fact. The dispute between Mr. Ghibaudo and the professional corporation, and the registered agent, even if it is true, has no relevance. That a professional corporation has to be served, and you serve the resident agent. If there was an issue related to it, he should have, and would have done what he did in June, which was to get rid of the resident agent and had it substitute Ms. Kramer in for the resident agent. But he didn't do that. And so a garnishee, whether it's an ex-wife or whether it's somebody who has a judgment against him personally, has a right to serve the writ of garnishment on the resident agent, and that is service. The court believes the testimony that the business practices of the resident agent were to send it off to Mr. Ghibaudo, and frankly, he says he didn't get it. And that's more difficult to weigh, but if I had to determine what finding is supported by preponderance of the evidence is that there was service. And then we get to this actual notice, which I'm not sure is particularly material, but there was actual notice of the writ and still no answer. There was a dialogue about the writ in March, and as a courtesy, this motion wasn't filed until a month after that dialogue took place, and the court finds that the writ was provided. And so this looks more like a pissing match between a judgment creditor and a former husband who is trying to protect judgment against the garnishee, which happens to be his solely owned professional corporation. The case doesn't involve any kind of evaluation as to whether or not Ms. Kellogg is credible or not, or whether she, the evidence that the court heard in previous proceedings. She is a judgment creditor. Her status allows her to serve a writ of garnishment on the garnishee, and all of the findings and conclusions of the court related to the validity of her remedies have nothing to do with her testimony. It has to do with the testimony of the fact witnesses, the employee of the resident agent at the time in January, the employee of the constable's office who actually did physical service, and her former counsel. And so the court is going to direct Mr. Nelson to make the findings and orders, and the request for judgment filed on April 21st, 2021 is denied. The court rejects the notion that the proof that was presented supports a finding that the garnishee was not paid the fee or wasn't stapled to the amended writ. In fact, the testimony was credible, that was the business practice and that's what happened, and he wouldn't have served the writ if he didn't check the day before and see that the check was attached to the writ. His testimony was credible that he delivered it to the place that he said he did in his sworn statement. The argument that the resident agent didn't have authority to accept the writ because they had, I guess, severed their relationship or contract is neither here nor there. If there's a beef between Mr. Ghibaudo and the resident agent, that's a civil matter that they can deal with some other place. As long as they're the registered agent, they're required to do their duty, which they testified that they did, and they receive service from a judgment creditor. The judgment creditor does not need to determine whether there's a good relationship between the resident agent and the corporation. Doesn't have to bother themselves with those kind of considerations. There was authority to accept service as a matter of law, and there was acceptance of service and actual service. And then as it relates to, fraud or collusion or whatever, I don't know. I agree with the general notion that the court did not set some sort of long or reasonable discovery period. I think it was June 2nd to end of July was when we said it. But when you look at these type of proceedings, it says you can't have a hearing less than 5 days. And the only reason why I allowed any particular discovery was so that there'd be an opportunity to collect information, subpoena witnesses, and to offer an opportunity to have a record in which the decision of the court to issue a judgment against the garnishee, no one would have to wonder about what the court based it on. And it wasn't based on some sort of paper or technicality or anything else. It was based on substantive proof. And so, I'll probably never do this again as far as, been here 22 years, never had a 2-day evidentiary proceeding on whether or not a writ of garnishment would result in a judgment against the garnishee. But I thought it was important in this case to make this record, especially on a case like this where it seems like everything is a laborious, ridiculous log on a dumpster fire, okay? So, Mr. Nelson, you're going to submit the findings and orders. I expect, since it's a judgment against a professional corporation, rights attached, and you'll be able to, exercise those rights however you want. You can file, nothing changes, Ms. Kramer, as it relates to the rights of the professional corporation to challenge either the legal or the factual findings of the court. Okay?
Thank you, Your Honor.
All right, so we're done
Your
for
Honor,
today.
pending this, I'm making an oral motion that the court stay this pending our appeal.
Yeah, I understand why you have to ask for that. The court's not going to grant an oral motion to stay. The court, if it thought that it didn't have a jurisdiction or the need to grant this motion, would not have granted it. But if you want to be able to, you don't get any static with the appellate court, because you might want to make a request for a stay or writ or whatever, you can submit an order that basically says that an oral request to stay the judgment is denied. And just make sure that Mr. Nelson gets a copy of the notice of entry for that. Okay?
Okay, Your Honor.
All right, thank you.
Thank you, Your Honor. Judge,
What do you need?
I'm gonna steal a log on a dumpster fire from you. I like that.